So what does it mean to follow the precedent? Like they have to follow the whole transcript, or how actually people could understand what means to follow a precedent?
It would be really what's being followed is the point of law, the legal principle that is established and of significance in the case that sets the precedent. So an example I would give, I suppose, is in contract law, the distinctions we have between offers and invitations to treat. If I had circumstances in a new case where somebody had said this person had made an offer and I had then accepted that offer, and the circumstances suggested that it was not an offer but an invitation to treat, that's an established legal principle with a long series of binding precedents that I would need to follow.
So let's talk about the elements, those key elements of precedent that we have, like obiter dicta or ratio decidendi, quite complex legal terms for many to understand.
Yes, I mean, ratio decidendi is not too bad because it sounds a lot like what it actually is in English. It is the reason for the decision. This is why a decision is being made. It's important to understand that to try and, I guess, get a holistic view of the actual outcome of a case. It is also actually very helpful to understand this if you're trying to distinguish from another case. You can say the reason for the decision in that case, the key considerations differ significantly from the present case.
So what is the ratio of the case? Where it can be found? How to find it?
If you're reading a law report looking for the ratio decidendi, it will usually be further down in the actual judgment itself, so towards the end of the actual report. But there is no specific place where they say, usually this is the reason. You might see it in some reports where they actually help to put a note on it, but a judge, I do not think in a judgment will specifically say this is the ratio decidendi.
So the ratio decidendi is drafted by the actual judge, right? It's like a thought of a judge, or what is it actually?
I would say so, yes. I mean, it's the judge's reason for making the decision, for reaching the decision they've come to in that case.
So, and how is it different from obiter dicta?
So obiter dicta is other things said. So it's not necessarily part of the reason a decision is made, but other considerations. So an example might be a case where people are trying to decide on whether or not a bicycle is a carriage. This is a real case. Actually, there was a discussion about whether or not a bicycle could be a carriage for the purposes of a road traffic offense. And if in that same discussion, one of the judges said, yes, I agree, but I think there would be an exclusion, for example, if someone was riding a horse. That is not part of the reason for the decision in this case. It is another thing said, but it may be relevant in another case. If you have a case in the future, you may refer to the obiter of a judge in a previous case and say, although it wasn't part of the reason for the decision and it doesn't create binding precedent, it is something that has been considered in the past and it is persuasive.
So a ratio decidendi, this is like the key principle from the case, yeah, that like the law formed in the case, if I correctly understand it, written by the actual judge who heard the case. And obiter dicta is like something which goes a little bit beyond, or some sort of own opinion on that case.
Yes, yeah, absolutely. It's not a key part of the decision in that case, but it's still something that could be helpful in other cases usually.
So we will use exactly the ratio decidendi in order to, to establish the law in the similar cases, right? What about obiter dicta? Can we also use it in any further cases?
We can use it persuasively, but it is not binding in itself. So the example that I gave of a judge perhaps saying that a horse might not be considered as a carriage if we're trying to interpret legislation, that in itself would not be binding. It's another thing said. But it is something we could introduce in another case and say, well, this has been considered before. It's not binding, but it is something that may persuade the court.
Okay, thank you very much. What is the role of the material facts in all of that? And if you could a little bit tell us, as it's a part of the concept.
The material facts, I would say, are actually just the circumstances, the scenario, the important things that we take out of the case in terms of the situation that it concerns. So material facts would be very relevant if we were trying to distinguish from a case. If I had a case concerning a boat, that is a material fact, and I would distinguish that maybe from a case concerning a car and say the material facts are different. The type of vehicle is very different.
So further application of the ratio decidendi would actually depend on the material facts. This is how we would argue that this case is similar and should apply the same principle, because the facts are similar. Basically, what we do, we draw similarities or we draw distinctions between those facts.
Absolutely. If I have two cases with similar or the same material facts, then I would be looking at binding precedent.